Good evening, and welcome to tonight's virtual book talk. Tonight, I'm joined by Dr. Julia Rose Kraut to talk about her book, Threat of Dissent, A History of the Ideological, Exclusion, and Deportation in the United States. Dr. Kraut is a lawyer and historian living in New York City. She was the inaugural Judith S. K. Fellow for the Historical Society of the New York Courts and an Andrew W. Mellon Fellow, a Foundation Fellow, at the New York Historical Society. We're very excited to welcome you here tonight. Thank you for joining us.
Thank you so much. I'm delighted to have the chance to talk about Threat of Dissent with you. And I am a big fan of the Tenement Museum. I always recommend its tours and its programs. And I am so happy to be able to participate in the Tenement Talk series.
Well, I'm going to kick it off then talking about the book. Can you give us an overview of the book and your research and writing process?
Sure. Threat of Dissent is a legal, political, and social history of the barring or ejection of foreign non-citizens from the United States based on their political beliefs, expressions, and associations. It's a chronological narrative, and so I begin with the Alien Friends Act of 1798, and then continue forward all the way to the War on Terror and the Trump administration. And I argue that the use of ideological exclusion deportation is a tool of political repression, and it's been used to suppress the threat of dissent, which includes criticism of US politicians and policies, advocates of reform and revolution, and challengers to the status quo and to capitalism. And what I also argue is that it presents a unique intersection of First Amendment and immigration law and history, and that it has served as this tool of political repression, and it has endured as this tool because the majority of the Supreme Court of the United States has interpreted ideological exclusion and deportations as an immigration issue as opposed to a First Amendment law issue, and thus has applied immigration legal doctrine. And that legal doctrine has insulated ideological exclusion and deportation laws from substantive judicial review and strict scrutiny and the application of speech protective standards. And that is how it endures to this day. It is an interdisciplinary history. So I am a lawyer and historian, and I drew on my training in law and history. And so I was able to include a lot of legal analysis of statutes and case law, as well as archival research. And the whole goal is to make this long history accessible. And so you should be able to understand this story, whether you have a background in law or history or not. It should be compelling and interesting. It has wonderful characters like Charlie Chaplin and Emma Goldman and John Lennon and Carlos Fuentes and Gabriel Garcia Marquez and Clarence Darrow. And I wanted to gear it so that each chapter can stand independently and then builds on the previous chapter and sets the stage for the next one. So there's a nice flow. You get a little bit of a line there with this history, and that you get the voices of those who passed and enforced the laws, those who challenged them, and those who were excluded and deported under them.
And you've done a wonderful job. So I want to start at the very beginning of this story with some laws that I think most of us are not very familiar with. Can you talk a little bit about some of these early formative ideological exclusion laws?
Yes. Yeah, so one thing that I argue is that the use of exclusion and deportation is consistent and continuous over time. But what you find is that the passage and revision of ideological exclusion deportation laws usually happens in the name of national security during moments of national insecurity. So during the war, on the brink of war, in the aftermath of a violent attack, during economic depression, or national or international upheaval. And so what I do is I trace ideological deportation all the way back to the Alien Friends Act of 1798. Some of you might be familiar with the Sedition Act and the Alien Act. And this is the Alien Friends Act, which provided the president at the time, John Adams, with tremendous discretion and absolute unchecked authority to deport any foreign non-citizen within the United States he deemed dangerous to the peace and safety of the United States. And so that is the first, what I call ideological deportation law. And it worked together with the Sedition Act. And the intention was, during this moment when we are on the brink of war with France, to suppress critics, including the Democratic Republicans. So this was a Federalist-dominated government, including of John Adams. And this was to suppress criticism and also to prevent treason and subversion within the United States. Now, it's noted always that John Adams never used the Alien Friends Act to deport. So there were no deportations under it, but that wasn't for lack of trying. And so what I talk a little bit about were these attempts to use both the Sedition Act and the Alien Friends Act to suppress dissent, and include a blank warrant signed by John Adams to do just that. And what I also do is I trace ideological exclusion to the early 20th century. And the first ideological exclusion laws passed during the War on Anarchy, which occurred in the aftermath of the assassination of President William McKinley in 1901 by a self-proclaimed anarchist named Leon Czolgosz.
And can you tell us a little bit more about that moment? What is going on that makes this pretty new law so urgent for the American people and government?
Well, what's interesting about that moment, it often doesn't really make it into the history books, is that we have anarchist assassinations or attempts to assassinate leaders abroad in Europe all through the 1890s. We as a country do not suppress anarchists, even after we had the Haymarket Affair in 1886, including a bombing in Chicago, and the imprisonment and execution of anarchists there. But we don't have any kind of suppression of anarchists at the time. And what happens is that President McKinley is assassinated by an American-born, a self-proclaimed anarchist, but with a foreign-sounding name. And there is a suppression effort to suppress anarchist meetings, anarchist newspapers, anarchist expression, including the passage of criminal anarchy laws, most famously New York's criminal anarchy law in 1902. Now, ideological exclusion comes into play because this was part of the suppression effort, that the targeting of foreign anarchists was part of the way that the United States is going to declare war on anarchy, and demonstrates the conflation of dissenters and radicals with foreigners. That foreigners are seen as the source of subversion, that they are responsible for anarchism, and that they pose a threat externally from those who are outside the United States and internally through those who are in the United States. And so Congress passes an act, 1903, the Alien Immigration Act, and that's the first act that bars, based on belief and expression and association, targeting anarchist speech. And the Supreme Court upholds the constitutionality of that act. There's a anarchist named John Turner from England, who was invited by the anarchist Emma Goldman to come and speak. And he'd been there before touring and lecturing, and he is excluded. He is deemed inadmissible under the Alien Immigration Act. And with the help of famed attorney Clarence Darrow, he challenges his exclusion as a violation under the First Amendment, and the Supreme Court upholds his exclusion and says that this is an immigration issue and that those seeking entry do not have constitutional rights, including under the First Amendment. And we are still dealing with that precedent today. So the question is how do we challenge exclusion and ideological exclusion? And I discuss that in the book.
So you talk at length specifically about those early efforts to exclude anarchists. You've spent a lot of time talking about the case of Emma Goldman and the intersection with not just questions of who the First Amendment applies to, but movements for free speech. Could you talk a little bit about that?
Yes. So what we have is the intersection of free expression law and immigration law. And this is what I mentioned kind of before, which is in this case for Turner, that you have the motivation is to suppress anarchist speech, and they're using immigration law to do it. And it's interpreted as immigration issue as opposed to a First Amendment issue. And the application of the plenary power doctrine, immigration legal doctrine, which requires judicial deference to the decisions of Congress, which has the power to pass exclusion and deportation laws based on national sovereignty and an inherent right to self-preservation, and the executive, the judicial deference to the executive to enforce those laws. And what you find is that, example with Emma Goldman, is that Emma Goldman is an immigrant. She becomes a citizen through derivative citizenship at the time through her husband. And she's very active. And there is a major move to try first to arrest her for the assassination of President McKinley, trying to link her with Czolgosz. He even says that her speeches set him on fire, but they can't link it because she was not involved with the assassination. And so the United States government is determined to get her out of the country. And the first step is to denaturalize her. And that's what they do in 1909, first by denaturalizing her husband, who she had been estranged from for quite a bit. And then in 1919, after World War I, in the wake of the Red Scare, she is deported under the Anarchist Exclusion Act of 1918. But they had to denaturalize her first to do it. So it took about 10 years.
And so you talk about the Red Scare and how this increases the emphasis on ideological deportation, but it also starts to broaden the focus. So what is happening in that crucial moment?
Well, a lot of people will recall during World War I, there was a lot of suppression of speech. And it's out of this moment that we get kind of the modern free speech jurisprudence. And that's primarily because the government passes the Espionage Act of 1917 and the amendment, the Sedition Act, and it's used to suppress dissenters from the war. There's a lot of focus on anti-war protesters and their prosecution. Now, at the exact same time, the government is also turning to suppression of anarchists and the international workers of the world, the IWW, also referred to as the Wobblies, and they become targets. And so they're also going to be using immigration law, at that time, the Immigration Act of 1917, and then later the Anarchist Exclusion Act, which incorporates the anarchist exclusions I mentioned through that Immigration Act of 1903, passed in the wake of the McKinley assassination. And they're using these laws to deport as well as to denaturalize during World War I and then afterwards. And so what this is, ideological deportation and denaturalization become essential parts of the story of World War I and free speech suppression. They're targeting radicals, they're targeting dissenters, they're targeting agitators, and they're using deportation, denaturalization to do it. Now, some people will recall the Palmer raids, and this is orchestrated by Attorney General A. Mitchell Palmer with the help of a young whippersnapper, J. Edgar Hoover. And they orchestrate these raids to arrest a whole bunch of radicals after the wake of, in the wake of the Red Scare. And so they're doing this in early 1920. And the focus is to arrest and then also to deport all of the foreign radicals. And they get started even before the raids with Hoover orchestrating the deportation of Emma Goldman and her comrade Alexander Berkman in 1919. And so all of this kind of works together. And what I discuss in the book is the nature of these laws, how Congress amends and changes them to be able to deport more and to deport those who had at any time, no matter how long they had been in the United States. So in previous laws, there was a limit, initially a 3-year limit and then extended to a 5-year limit where you could be deported within 5 years of entry. And by 1918, in the Anarchist Exclusion Act, those limitations are eliminated. And so what happens is that that act is on the books, not only to be used in 1919 and 1920, but through the 20s and through the 30s until 1940, where it is incorporated some of these provisions into the Alien Registration Act of 1940.
And I want to follow up on that because you spent a lot of time talking about how the government determines who is ideologically dangerous, and that is expanded with subsequent laws. So can you walk us through a little bit of that change in this crucial post-war period?
Right. So we have a switch of what the threat is. We have initially this threat of anarchists and violent anarchists and those who are influential like Emma Goldman. And then when we have, with the introduction of Bolshevism and the Russian Revolution, we have a transition. So we go from anarchists to wobblies to Bolshevik and Bolshevik supporters, and then those who are members of early communist groups, and then the Communist Party. And I trace this all the way up so that there is the threat, even through kind of McCarthyism, of communism. And those who are members of the Communist Party are those part of communist front groups. And then we take that on to eventually a switch from communists to the war on terror and the threat of terrorism.
So you write about people being suspect because of this idea of guilt by association, and that is legally defined in different ways in this period.
Yes, and so what you have is within the law. So what you have is these laws target belief, they target advocacy, but also membership and affiliation. And the question is, you know, how do you define membership? How do you define affiliation? What happens when you stop being a member? And so the laws continue to change to close loopholes and to also be able to expand so that even if you were no longer a member, if you were once a member, you could be deported. Remember, deportation and denaturalization go hand in hand. So to be able to strip one's naturalization, one's citizenship, makes you easier to deport. So in the efforts and the drives to deport, both during World War I and then also in the late 1940s and into the 1950s during deportation drives during the early Cold War, you have also efforts to denaturalize, and that would be based on fraud, misrepresentation, or a lack of attachment to the principles of the Constitution. And they used membership or affiliation to assist them in trying to prove that you lacked an attachment to the principles of the Constitution because of your beliefs or your associations, and therefore to invalidate your citizenship in order to deport you.
But it's such a complicated story because on one hand, you're showing us that how various laws are defining your membership. You've been a member of a certain group within 3 years, you don't qualify. On the other hand, you say there's a lot of discretion in how these laws are enforced. And in some ways, there's a lot of back and forth depending on who are the officials in charge of enforcing these particular laws.
Precisely. And that is one of the arguments of the book as well, and something that I try to draw out, which is that because of the nature of immigration law, there's a lot of discretion, and there's a lot of unchecked power held by officials who are in charge of enforcing these laws. And that could be consular officials who are dealing with visa applications. That also could be the Attorney General, the Secretary of State, Secretary of Labor, depending on who is in charge of immigration and admissions or deportations at the time. And so what I show is that there are some who are in these positions of power who deport or want to deport or exclude more, or want to delay or defer deportation and try to prevent deportation. Lewis Post, during the Palmer raids, the Assistant Secretary of Labor, is one that used his interpretation of the law to try to deport less and to try to find ways that he could prevent deportation. While you had others like Secretary of Labor William Doak in the early 1930s, who was part of the immigration deportation drives, pushing for deportations as a way to solve unemployment during the Great Depression. And he used his authority to try to deport more. And so what you find are these kinds of tussles and differences with whoever is in charge, and the vulnerability of those non-citizens in the United States, as well as those who are trying to seek entry to these laws, as well as those who are in charge of enforcing them.
And so as you have this moment of back and forth, not so much back and forth, but different people enforcing the laws with, say, different amounts of vigor.
Yeah.
And you have sustained concern about communism. In the 1950s, we have a crucial law. We have the McCarran-Walter Act. And I want to spend some time talking about it because, you know, we've talked about it on other museum programs. We're usually thinking about it, though, in terms of its effect on national origins laws and debates about the origins of people admitted into the country. But you show there's a really important aspect, ideological aspect of this law that it affects ideological exclusion and deportation that persists to the present. And I don't think this is a law that most people are familiar with. So could you talk a little bit about the genesis of the law, but also what the law contains in this particular aspect?
Sure. And I devote a entire chapter to exclusion and deportation during the McCarthy era and from the late 1940s through the 1950s and even into the 1960s, so kind of the early Cold War, and then the McCarran-Walter Act, which is passed at the height of McCarthyism. And McCarran-Walter Act, which is actually the Immigration and Nationality Act, so it is named after its sponsor, Senator Patrick McCarran and Congressman was it William? I think it's William Francis. I just blanked on his name. Oh my goodness. That's okay. And it's passed at the height of McCarthyism, as I said, and it is the culmination of all of these laws that I've just talked about. It's Walter Francis, by the way, not William. I was close. It's Walter. Okay, and so it is the culmination of all of these immigration laws, including the National Origins Act, quotas. So you had the Reed-Johnson Act of 1924, and so the national origins quotas are part of this 1952 law, as well as ideological exclusion laws. Now, the ones that I had mentioned before did not explicitly include communists as a category. And what the McCarran-Walter Act does is it includes those who advocate believe in and are members of organizations, world communist organizations. So it's directly focused on excluding or deporting communists or those affiliated with Marxist organizations. And it's huge. It's a kind of all-encompassing. All those anarchist exclusions are in there. And it gives a lot of power to the Attorney General to not only deport or exclude, but also to admit and to admit on a waiver system. And so what you have is that those who are seeking entry have to go under an examination to get their visa, which are questioned about their affiliations and whether they are excludable under all of these provisions of the McCarran-Walter Act, but also can apply for a waiver that despite their inadmissibility, they should be allowed temporarily as a non-immigrant, as a visitor, to come to the United States. And the Attorney General has the authority, upon the recommendation of the Secretary of State, to grant that waiver or deny it, and does not at that time have to provide a reason. And we are still living under the McCarran-Walter Act. And the provisions are still live today, incorporated into our current immigration law. Recently, we've seen President Trump use provisions of the McCarran-Walter Act, 212F, suspending entry to certain non-citizens from the United States that he deems detrimental to the interests of the United States. That was under the McCarran-Walter Act. But in the book, I talk a lot about the effect of these exclusions and deportations. And there were not a lot of exclusions or deportations, but the threat of deportation chilled speech, as well as the exclusion and having to undergo this examination and discussion of your views, the delays in processing visa applications, the concern about exclusion, and those who were caught up in the McCarran-Walter Act and provisions in other acts before that, like Graham Greene, Charlie Chaplin was excluded because he was going to be subject to an examination of his morals and his views before re-entry. He had left the United States to go on a tour to promote one of his films. And the Attorney General said, you have to submit to this examination. He said no. He refused and lived abroad. Carlos Fuentes, Gabriel Garcia Marquez later were excluded under the McCarran-Walter Act and continued to have troubles getting visas all the way through the Cold War, admitted under conditional visas, like Carlos Fuentes, which limited where you could go, what you could do, how long you could stay. So this was a very serious hindrance to those seeking entry, and also a threat to those within the United States. And what you find too is that there were a lot of arguments against it. And those within the United States were embarrassed and said, you're damaging the reputation of the United States abroad, especially during the Cold War. What separates us from the Soviet Union? You are creating, an iron curtain of the West, some abroad commented. And you are also hindering exchange, free expression, as well as scientific exchange and discovery. There were a lot of scientists who ended up being barred or having difficulty obtaining visas to come to the United States. And so I also discuss their trouble, as well as the embarrassment and the outrage by American scientists over their exclusion.
You have a number of very interesting cases in the book that attract a ton of public attention, but this law gives the government an incredible amount of power. Now, before I continue, I do want to remind our live viewers that we'll have a chance for your comments at the end. So please feel free to put them in the chat at any time, and we'll get to them in just a few minutes. But I did want to keep pushing the timeline forward because you have a really interesting case by the time we get to the early 70s, you write about how Richard Nixon use the law and use a renewed focus on exclusion of communists. And you have a really interesting case of a Belgian Marxist intellectual, Ernest Mandel. Can you talk a little bit about his case? Because it has some really interesting implications for the interplay between ideological exclusion as well as free speech.
Yes. So despite immigration reform in the mid-1960s with the Hart-Celler Act of 1965, which eliminates those national origins quotas, these ideological exclusion provisions remain. And again, we're still under the McCarran-Walter Act, even with the Hart-Celler Act, removing some of those national origins quotas, which means that the ideological exclusion provisions can still be used and were used under the Nixon administration. And I devote an entire chapter to discussion of the Nixon administration, including extensive analysis of the Ernest Mandel case. And what I find is that the abuse of power under the Nixon administration to suppress critics, suppress dissent, and his determination to do anything at all cost to get reelected. Ideological exclusion was part of that, as well as attempts to deport and retaliatory deportation, which is what I discuss with the attempt to deport John Lennon at the time. Now, Ernest Mandel is a Belgian Marxist economist who had come to the United States 2 times before, and he's invited once again by fellow academics to visit their university college campuses. And despite previous visits, he is excluded. He is excluded under a provision in the McCarran-Walter Act. And because of his advocacy and expression of world communism, his belief in world communism. And this is unusual. This happens in 1969, and he's excluded under this provision passed at the height of McCarthyism in 1952. And it is something that startles him, and he discovers that he had been admitted under a waiver, and he had no idea. And that apparently this time, under the Nixon administration, they say, well, you violated the provisions of your conditional visa under the waiver because you went to a cocktail party, and that was not part of your itinerary. And he said, I have no idea. And if you let me in, I'll stick to your itinerary, no problem. And the State Department says, okay. And Attorney General John N. Mitchell says, no way, refuses to grant the waiver. And what you have is not only tension between the Justice Department and the State Department, but you also have now a battle and an outcry from academics who say, what are you doing? This is a violation of academic freedom. It's a violation of free speech. This is a form of censorship. What are you afraid of? This is McCarthyism revisited. This is something that should not be in 1969. And Ernest Mandel is represented by one of the most famous attorneys in the United States, a First Amendment advocate named Leonard Boudin, and with a young lawyer named David Rosenberg, they devise a challenge. And instead of arguing that Ernest Mandel has a constitutional right to come to the United States, which he doesn't, they say that the professors who invited him, his exclusion violated their First Amendment right to receive information and to hear. So under the First Amendment, you have the right to speak as well as the right to receive information to hear. And so he gets around that Turner case I mentioned before and the precedent there by focusing on the rights of the Americans and those within the United States and their violation of First Amendment rights through the exclusion of Mandel. And it goes to the Supreme Court. And the Supreme Court, although upholds the exclusion does also uphold the right to challenge exclusion of those within the United States. So this pathway, this unique challenge, this First Amendment challenge, is what is still used today to challenge exclusions from the United States based on the harm to those within the United States. And also tries to curb, the Supreme Court curbs the discretion held by Attorney General Mitchell by requiring a facially legitimate and bona fide reason. And that's the standard that we still use today under the precedent set in Klondike versus Mandel. Now, Ernest Mandel was not the only one who was excluded. Shirley Graham Du Bois, W.E.B. Du Bois's widow, also faces exclusion under the same provision in the McCarran-Walter Act by the Nixon administration. She eventually is let in with kind of a provision such that she's not allowed to attend events that would have her speaking on college campuses. So there is a limitation there. Eventually she gives her itinerary and they let her in. And then, of course, the focus is on John Lennon and his popularity and his criticism of Nixon administration and the war in Vietnam. And there is an unsuccessful effort by the Nixon administration to suppress dissent, including to use deportation of Lenin to do just that.
But they're not saying they're not saying straight out that he's threatened with deportation for ideological reasons.
No. So this is a part of kind of retaliatory deportation, which I explained in the book. And many people, some might recall this, many people don't know, that there was an attempt to deport John Lennon by the Nixon administration, but there was a real concern about his popularity and the fact that he might endanger Nixon's reelection prospects. And why not use all the tools in the toolbox to get him out of the country? And so they use a conviction in England, a drug possession conviction, which he had been admitted to the United States on a waiver. This was under a exclusion provision that pertained to this conviction, and he's admitted to the United States. And then there was a rush to not renew his visa and to deport him. And the reason why is that is accelerated, which is under something called prosecutorial discretion, is because of his dissent and his expression. So technically, it's not under one of these ideological exclusion provisions, but falls under something called selective deportation or retaliation. That would be a violation of the First Amendment by advancing his deportation and selectively deporting him based on his views and expression.
And then you show by the 1980s, the situation starts to shift. So it moves away from the anti-war criticism, it moves away from a fear of communism, and the focus becomes anti-terrorism. Can you explain that shift and how that ideological exclusion is mobilized in that context?
Well, the McCarran-Walter Act is still holding strong by the time we get to the 1980s. And well, there have been attempts by Congress to provide a little bit more oversight in terms of those waiver provisions. There has not been the same kind of curb or initiative to repeal or successful initiative to repeal. There has just not been any incentive to get rid of these national security provisions. That's what they were called, these ideological exclusion deportation provisions. And there is a push, though, during the Reagan administration. And the Reagan administration begins to deny waivers, but also use other provisions in the McCarran-Walter Act to exclude critics of its foreign policy, and based on membership in certain organizations, and tries to circumvent some of these protections that Congress had provided. And so there are legal challenges inspired by that legal strategy developed in the Mandel case, and challenges brought by those within the United States to get those excluded under the Reagan administration into the country. But there's also a lot of publicity. And again, the arguments that we see in that Ernest Mandel case, kind of going back and saying, why are we turning back the clock? Why do we still have these laws on the books? Why are we still excluding based on membership or association and expression? And why are we doing it under a law passed at the height of McCarthyism? Returned during the Reagan administration. And they point to those anarchist provisions. They point to the world communism, just as we're beginning to end the Cold War and say, what are we still doing? And so there is a major push. Organizations like PEN America and the American Civil Liberties Union also lead the charge, as well as Congressman Barney Frank, to try to get rid of these ideological exclusion provisions. And to no longer leave it to just the courts to handle. And they are successful. And yet, there is also a focus on terrorism at the time. And while at the exact same time that the threat of communism is waning, the threat of terrorism is increasing and heating up. And you find that terrorist provisions remain, as well as are added to immigration laws. And so I titled the chapter in which I describe this transition, "One Door Closes, Another Opens." And that's where you see this little bit of a transition here from exclusion, deportation based on belief and expression, to those with association, but association with terrorism. And this becomes kind of a back door. We talked a little bit about guilt by association and membership. And what we see is that the broadening interpretation of what a terrorist organization is, as well as support to a terrorist organization or questions of membership that we saw with communists, return now with this shift towards terrorism. And what I do is I track this from the 1980s through the 1990s, well before the War on Terror. Already we see this shift towards use of terrorism provisions to exclude and deport, and as well as this concern over the designation of foreign terrorist organizations, as well as affiliations, memberships, and questions of support to them, which trigger or are part of both expression and association rights.
And you show, as we move through the 80s, 90s, then especially once the War on Terror begins, there's a very fine parsing of what it means to be materially supporting a terrorist group. Could you talk about some of those high profile cases? Because I feel like these are stories that now we're talking about that got a lot of public attention at that time.
So I wrap up my chronological narrative in the War on Terror, and I bring it actually as close to the present as possible. And I start with a number of ideological exclusions under these anti-terrorism provisions at the beginning of the War on Terror, in the wake of the September 11th attacks. And we have that under the Patriot Act, as well as other subsequent legislation. And you have exclusion initially based on some cases, the endorsement or espousal of terrorism. And then there also a shift to material support of terrorism. Again, endorsement and espousal triggers more of kind of First Amendment or expression rights. Material support is a little bit different and could be interpreted in a different way, such that it might not trigger those rights. And so what you find is that the concerns about material support in the 1990s return with material support provisions in the War on Terror. And so I discuss a case of the exclusion of a Swiss scholar named Tariq Ramadan, who was invited to come to the United States to teach, and finds that his visa has been revoked. And he is barred from the United States. Initially, one says under this endorsement or espousal of terrorism, and then that shifts to material support based on contributions he made to an organization. And I follow that case. And what the challenge is brought by those within the United States, again, using the Ernest Mandel legal strategy, PEN America, the ACLU, challenge the exclusion as a violation of the First Amendment. And eventually he is led into the United States during an administration change under the discretion of Secretary of State Hillary Clinton in the Obama administration. But there had been successful challenges to his exclusion based on use of material support. And what you find today during the War on Terror is this material support provisions have been upheld by the Supreme Court and are still a threat to associations, associational rights, and present guilt by association, even those within the United States. There's a case I mentioned, which is Holder versus Humanitarian Law Project from 2010, which upheld the constitutionality of some of these material support laws. And that is something that not only is a concern to the suppression and of expression and guilt by association within the United States, but also how it plays out in exclusions and deportations. And so, as I said before, we are still kind of dealing with a backdoor and use of ideological exclusion through terrorism, as opposed to an ideology like anarchism or communism. Today, the challenges include social media and how social media can play a role. In the 1950s, during those examinations to get a visa, you would have to list your affiliations and associations and memberships. And now you carry them with you, all of your affiliations and associations, and all the people that you know and your connections on your phone, on your laptop, on your social media. And so there's been a major concern about border checks of citizens and non-citizens of their phones and their laptops, and data collection through social media, but especially along with requirements to disclose your social media handles on visa applications. And so that is kind of the new frontier. Those who are civil libertarians have issued warning calls and have said that this is very concerning, and have actually referenced McCarthyism and the McCarran-Walter Act and some of these exclusions experienced in the mid-20th century, just as a warning, and saying that we are in danger of ideological exclusion once again, the use of social media.
But I want to return to that just a few years back in history before social media to talk more about the Ramadan case, because it raises an important issue that's a theme throughout the book of the discretion that the federal government has to interpret the law. And there was a robust discussion of what it meant for him to supposedly materially support terrorism, a discussion of who qualifies as a terrorism, who gets to terrorist organization, and who gets to make that determination. So could you talk a little bit more about that process during the War on Terror?
So what you have is that, and this is also covered a bit in that case that I referenced, Holder versus Humanitarian Law Project, in terms of what constitutes support. And this is something that we're still dealing with today in terms of anti-terrorism. What happens when you support an organization that supports a then designated foreign terrorist organization, and what does support mean? And so does support mean that there is a contribution? Does it have to be a monetary contribution? Does it have to, can it be broad advice or counsel? Can it be necessarily giving someone, an organization, a platform, or supporting a particular aspect of an organization that has nothing to do with terrorism? And so these are kinds of discussions that are happening in the 90s, but also now are happening today and in the early years of the War on Terror, in terms of how do we interpret what is a terrorist organization? The Secretary of State can designate a foreign terrorist organization, and who gets on the list and who is taken off the list. Do you have to know if you are contributing or supporting to a foreign terrorist organization? And how do you know? And how do you know if the organization that you're supporting supports a designated foreign terrorist organization? And so what the problem with this is that it can also chill speech. And so when I say chilling speech, it's the inhibition to speak or express oneself or to exercise your association rights under the First Amendment. And that becomes a real issue, not just a focus on suppression, but also your self-censorship. And that is also partly a violation of one's First Amendment rights. And so that becomes also a concern. Are you too afraid to join an organization, to support an organization? What are you liking on, going back to kind of social media, what are you liking on Facebook or on Twitter? And can that be used against you? Can that be used to exclude you? And so with Ramadan's case, these were charitable contributions that he made to an organization that he did not think was a designated terrorist organization. And so that case kind of hinged on whether he knew what he knew and when. And so that was still kind of ongoing when there was an administration change, and the Secretary of State Clinton let him and another scholar in through her discretion. But again, that raises the kind of the point that you mentioned earlier, and that's something that I highlight in the book, which is it depends on the administration. We have laws where it's very much dependent on who is in charge, who is administrating those laws, who is part of the administration. Today, we see an administration with extreme vetting policies and a drive to exclude and deport. The next administration could be different. And the real issue that we find today, and something that I bring up in the book, I cover the travel ban, also referred to as the Muslim ban, and the extreme vetting policies and use of social media. But we also find immigration reform is very much an issue, and something that I argue in the book is that ideological exclusion deportation should be part of that conversation. And I mention one act that was recently passed by the House of Representatives, the No Ban Act, which is seeking to repeal the travel ban, but also wants to include kind of anti-religious discrimination provisions in the law. The Hart-Celler Act focused on national origin and not on religion, in terms of where you cannot discriminate when you exclude. And also this No Ban Act provides much more congressional oversight and raises the standard of scrutiny that is given to those who are used to evaluate those who are making decisions to exclude. And so it curbs a lot of that discretion, as well as provides oversight and scrutiny to those decisions by consular officials to exclude, as well as to the president to suspend entry. Now, who knows if this is going to pass and if this is going to become law, but it does provide a pathway and a roadmap to future immigration reform and laws, that oversight that focus on congressional action and that raising the level of scrutiny is very important. And so in addition to focusing on these new methods of exclusion and deportation, ideological exclusion and deportation, we need to also take a look at how to prevent it in the future. And that's not necessarily through the courts, but through Congress.
Since we have time for just one more question, I do want to follow up on the travel ban, because you end the book talking about the travel ban and the legal challenges to the travel ban. And it, in some ways, brings us full circle back to conversations about the First Amendment. So can you talk about the role of the First Amendment and the judiciary's deference to the powers of other branches of government when it comes to determining who is allowed to enter the United States and how that determination is made?
Sure. Now, the travel ban and the argument, the constitutional argument against it, as I mentioned before, this travel ban was under a provision of the McCarran-Walter Act, that 212F, which places a tremendous amount of power and discretion in the president to suspend entry to foreign non-citizens. And this concerned the First Amendment, but not necessarily expression or association, but religion. And the challenges to that, to the suspension of entry, the constitutional challenges there were to the Establishment Clause, raising questions of that this travel ban was motivated by religious animus. And that constitutional challenge was not successful in the court. So the Supreme Court in Trump versus Hawaii in 2018 upheld the travel ban and the president's discretion and authority under 212F. And this is an example of the plenary power that I talked about before and that I talk about extensively throughout the book, which is that the deference, judicial deference to powers of Congress to pass laws like 212F, and the power of the executive to enforce those laws and to act under those laws. Now, national security is another part of judicial deference that we find. So I mentioned before that Holder versus Humanitarian Law Project, and their Chief Justice Roberts upheld the restriction based on national security and judicial deference to the national security determinations by the government agencies and by Congress in terms of passing those laws and determinations of material support. And so Chief Justice Roberts, once again, in his majority opinion in the travel ban case, defers to the executive, defers to in questions of national security and under the plenary power doctrine. So what you have here is hopefully by the end of the book, when I discuss the travel ban and this use of the plenary power doctrine, and this judicial deference, as well as deference when it comes to national security and arguments of exclusion based on national security, that travel ban case becomes more understandable and less surprising than it might have been, because you've learned from history and you've learned from this story of ideological exclusion and deportation. And I found that I had not wanted to take it so close to the present. That's not what historians kind of do. So it was a real question. I mentioned that this No Ban Act, in terms of its response to the travel ban, I slipped that just kind of under the line, that I brought it as close to the present as possible. But when I read that decision in the travel ban case, I realized it had to go into the book, because what this book provides is not only the history but the law to understand that decision, but also the pathway forward in terms of where we, again, when we talk about challenges and the way forward. And the fact that the courts, as I said in my argument, have contributed to exclusion, deportation being tools of repression. And that we see that the courts and their adherence to the plenary power doctrine, interpretation under this immigration legal doctrine that insulates review for a substantive judicial review of these laws is a problematic. And the pathway forward is not necessarily through the courts, but it's going to be through Congress. And the travel ban demonstrates that, but the book does as well.
I'm so glad you included that, because it makes so much more sense in this context. And this is a history that most of us are unfamiliar with, don't have access to. You've done the hard work of putting all of the pieces together for us. So since we're at time, I'll remind everyone watching that the book is Threat of Dissent. You can purchase it from the Tenement Museum bookstore online. We'll have a link for you in the chat. Julia, thank you so much for joining us tonight and for your time. We appreciate it.
Thank you.
Thank all of you for watching. We appreciate your support. If you're interested in more programs like this, consider becoming a member of the Tenement Museum. We'll see you next time for another book talk. Good night.